Yes, Janet. It's right there.
He kind of rolled with it. So your recommendation was just to reinstate and whatever happens, happens?
He did residential, so the only thing that my concern was making sure that he had somewhere to stay so that he would be easy to find.
And Salvation Army did that.
But I do understand, the RSET treatment as well.
I just worried that I said it, that he'd walk away from it eventually, that it'd be good for,
Agreed.
and then like, cut your hair?
Yeah,
That-
I would get this one for his particular case. I would have gone with the RSET as well, just as fine. Because he's still easy to find.
Yeah. All right, why don't we talk about some of the folks who are not in custody? Maybe we can move things along a little bit, try to catch up. Would you mind grabbing Ms. Wood? If you have, well, do you have a case where someone's not in custody? What case is that?
Cameron Wright, Your Honor,
He is the first position on our inquiry. Okay,
here in court, and we would love to be here now. I believe his brother who brought him here has a doctor's appointment to get to.
okay.
He is on for a status update, and I'm gonna let Miss Singleton.
Oh, wait, this is the Mr. Wright, and he wasn't able to make it last time, and you're back with your mom, and,
She's in the car, Your Honor, but the brother has a doctor's appointment and. So-
okay, the gentleman with the blanket around him?
Yes, he's in a wheelchair.
That's okay. No. Emergencies we got to deal with it. I just want to make sure everyone's doing okay. Let me type in one thing here and then let's have that update. So, and this does not need to be on the record. Mr. Wright, last time you were supposed to be here, Ms. Singleton said things had gotten a little bumpy. I can't remember. I may not get it right, so don't panic, but maybe like he'd been kicked out of At Promise or there was an issue at Promise, which is where you were supposed to get a lot of resources, like getting your GED, et cetera. Tell me what's been going on.
It was one good, if something had happened, so I already knew like what I got on my case, so like I ain't like how I knew I usually would have went by like it would have just been something totally different. But I went to my mom and told her like what was going on. So not knowing my mom, I thought she was like they're gonna go to the front and ask T like what been going on, but she hopped out she was asking me the boy a question, but the girlfriend started saying something like getting disrespectful, and she was like, I ain't no child, so like basically what you be talking to, like they was just word back and forth, and I guess it got me kicked out.
Your mom and a teacher there got into an argument.
A student.
A student? Your mom and a student got into an argument?
It wasn't supposed to go like that. She just started talking to my mom wasn't speaking to her shit. And my mom was like, I'm not talking to you. She just kept
Because your mom and a student got into an argument, the At Promise folks said, you know what, let's just keep the rights out of here.
It was the
Kinda?
mother and the teenage girl got into a verbal altercation where there were some threats and some comments made. His mother's ex-boyfriend jumped out of the car. There was some clutching of the belt. There was a thought there might be a gun. There was some threats of physical harm. And Cameron, I was told by people that observed it, tried to stop the whole situation. Tried to tell his mother to get back in the car, tried to tell the boyfriend to get back in the car, tried to calm everyone down, but the program felt unsafe.
Sure.
And they could not figure out a way to allow Cameron to continue coming without his mother ever showing up again.
Because she helps get him to places, and got it. That's a most unfortunate outcome. I heard you say ex-boyfriend. Is he not so present in mom's life anymore?
No, he's not. She and I have had multiple conversations since this occurred. There was other things that happened between him and her later over the next week, and they are no longer together.
Okay,
She was able to locate housing because she was a little unstable with her housing, and so she has steady housing now. And Cameron has been with her since the incident happened at the Promise Center. There was also some situations with his dad and his mom about what happened, and so he's with his mother right now. She did take him today to Perry Learning Center in Clayton County, which is what's near them, and enroll him in the GED program.
okay,
The Promise Center still would like to provide him the mental health services, so I provided her the contact information to schedule that. And he had already completed 67 hours of the 120 community service at the Promise Center. And they've said that they would assist him with finishing the last hours as well.
meaning he would come to the At Promise
They'll
Center?
help him locate another.
Another.
Yes, I had spoken with them about him possibly going to because they have 3 centers, another center, but they just don't want to take the chance.
Sure. Mr. Wright, what kind of work were you doing for community service?
Like cleaning up and helping out around the at-home center when I was doing my GED program.
Okay, how far did you get in the GED program?
I got to practice.
Good, okay. And can you, through the Perry Learning Center, pick up where you left off, or do you have to start back all over again with 1 + 1 is 2?
I start. No.
Yes,
Okay.
sorry.
Yeah.
I spoke with the Perry Learning Center.
He has to start, but I guess if he's taking practice tests, that may, I don't know if they'll accelerate him through it or what. Nope.
He'll take another pretest.
Okay.
And they'll determine what level he's on. And
Okay.
we'll go.
Got it. All right.
And the Covenant House, which is at the Promise Center, who were very involved with him, have agreed to still help him find housing when he turns 18 if needed. So they want to stay plugged in from afar as they wait to see what's gonna happen.
How old are you now?
16.
16. All right, you're not gonna be 18 for a little while.
The 17th birthday is December 25th, which technically
Christmas
ends my
birthday.
supervision, and he transitions over to adult probation at that time. He will have been under my supervision since 2022, and getting credit for all of towards the probation for that time.
Okay, well, again, thank you as always for your supervision and the work that's done. Ms. Gordon, I don't like yanking Mr. Wright out of life's routines to come here, but I can't help but note that a lot of what Ms. Singleton said is, and today this happened, and today this happened. And I don't think it's a coincidence that also Mr. Wright had court today. So I'm wondering if we want to have another in the new year at some point, check in, if only because that will advance balls that got stalled between now and then, because it's a complicated situation he's in.
I understand, Your Honor, and that's fine. That's
Okay, I don't mean for this to go on forever and ever. Mr. Wright will get sick of it anyway. But there's also a fairly meaningful transition, because if on Christmas Day, Ms. Singleton has to say farewell, then it's a different kind of supervision that, hey, we just got started and he's not in custody. So we're just having a little conversation. Are we good back there? Excellent, thanks. It may be supervision that is done in a way where stuff doesn't happen as promptly. And so checking in can help that way as well.
yes, Your Honor. I agree.
Okay. Then I will work with Ms. Nelson to get a date. It'll be late January, early February, so we get a month-ish of, no, Ms. Singleton, to see how that's going. And figure out what makes the most sense. I don't know what address is in the system right now for Mr. Wright. It sounds like it has changed over time. Getting you notice is enough, and you think you'll be able to track Mr. Wright down?
Yes, Your Honor.
Okay, all right. Mr. Wright, tell me something that you've enjoyed doing since I last saw you. Yeah, something that you like, hey, you know what, I play Call of Duty all the time, or I take care of my little brother, or what's something that you've enjoyed doing? I hope you can come up with something because I haven't seen you in a little while.
Oh,
Nothing good?
ain't that bad.
Okay, it's all neutral.
Yeah.
Nothing bad, nothing good. No encounters with police? Good. Okay. Remind me, are you the big kid in the household or are there older kids than you?
Either one older one.
And is he in the household with your mom?
Yeah, sometimes.
Sometime. What does that
He
mean?
want to.
Oh.
He old enough, he go if he want.
Is he done with school?
Yeah.
All right, so he comes and goes as he wants. All right, and then how many younger than you?
2.
Okay, your brother here?
My little sister.
Okay, is she in school right now?
Yeah.
What grade is she in?
I think she in first, yeah.
Okay. And is your brother normally in school?
We going through the process today too, but we ain't had time, cause we had to do all my stuff. So
Okay.
we still got.
All right. Anything else, Ms. Gordon, we need to talk about?
No, yeah.
All right, well, we'll set a date, like I said, in maybe early February. You'll get notice of that. And then if you can just make sure Mr. Wright is here. And if for whatever reason that date being here is particularly disruptive, just let me and Ms. Nelson know and we'll figure out a different time. Okay? We'll miss you on the case.
Somehow I don't think I'll be too far away. I tend to linger.
Good.
Around here, I tend to linger with the group.
All right.
Does Cameron need to get any type of reporting instructions today, or should I just reach out with you when it gets closer to his birthday to make sure?
It'll be 48 hours within his 17th birthday.
Okay, and I'll speak with his mom and give her all the information. I know where he has to go and what time. And I have that video link for them to watch the video before they go. Yeah.
Great.
Okay.
Any questions, Mr. Wright? All right, what are you doing for Thanksgiving?
At my grandma's house.
What is the favorite dish your grandma makes?
Yeah.
Yams? So that's something you enjoy? All right, so in a couple weeks, you'll be enjoying yams. Be safe out there.
Thank you, Judge. May we be excused?
Yes, ma'am. Thanks for being here.
Thank you, Your Honor.
Sir,
We've got a giant quick announcement on Joseph Cooper. I'm not sure what position
number 3 on our inquiry, Mr. Cooper, you're not Mr. Reba.
I'm Jason White from his office.
All right, you're Mr. White, and you or Mr. Reba were supposed to meet. Is Mr. Cooper here?
He is right there.
There's Mr. Cooper, to meet, to get some documentation to give to Ms. Davis, who is now Ms. Smith, was it to see if he was eligible for the diversion program or that he actually had, this is an old case, hopefully he completed it.
Completed, Judge.
And
I believe the state has presented the court with an order.
do I have the order or you will be presenting an order?
It's my understanding that it was sent to the court on October 29th by Mr. Deontay Pollard as part of the diversion program.
Okay. Let's see. I don't have anything in the docket, but he wouldn't have put it in the docket. We would have signed it by now if he sent it, but we can reach out to you to work through it. But it's you're representing Ms. Smith that either you or Mr. Pollard or someone associated with the adult diversion program has reviewed the paperwork that Mr. Cooper provided through counsel, and it does appear that Mr. Cooper has satisfied the requirements of the adult diversion program.
Yes, Your Honor, I had a chance to look at those documents. I then reached out to Mr. Pollard, who then confirmed that the defendant did complete successfully the program. If he did not send that order, I'll get that order over to the court.
Okay, well, don't send anything yet. We'll bug you if we can't find it, okay? I think that's it, Mr. White. Anything else?
No, Judge, that's it.
All right.
Any excuse?
Yes, thank you for coming, Mr. Cooper.
Thanks, Judge.
Is Richard Shanks here?
He was here, but his case was dismissed.
What? Oh, okay, that's what I want to make sure. So he did comply with, and the state has said, yes, we dismiss?
Yes, the null cross order has been filed. I'm sorry, he was here and I did say he could go because his case was dismissed. I thought.
I'm not upset if that's really what I just want to see. Yep, look at that. The null pros was entered a few days ago. Good. That's why we're checking on these. Null pros. Same, you have a client, last name Spears Dingle?
Yes, I am still talking with Mr. Dingle. We have an offer. I'm just need a little bit more time to speak and I will let you know what we're doing today.
Is he here?
Yes. Okay, he was here. I will get him. He's outside.
Okay, sounds like all your clients. Well, he doesn't need to come in right now. We're good. But so he did not complete diversion and instead he's going to enter a plea?
Yes, so
Okay.
Diversion, he had some issues with homelessness and stuff, and then the person over diversion said he can't come back. So now we have a misdemeanor plea possibly on the table. So we'll.
Okay, so you'll talk with him and let me know what we're doing today.
Yes.
Great. I need to see him before he goes if we're not resolving it. How about Marcus Blue?
That case was reset. We emailed this back and forth because he was supposed to go to diversion, but I never got the diversion information, even though I kept emailing about it. And so there was emails back and forth about us resetting him. So I think we gave him 6 or 9 months out to do the diversion, but that is definitely in the emails.
Yes, no, and on Halloween, I entered, so this calendar was published before then, so I guess on the calendar, and then people realized that it hadn't clicked with the DA's office, so he's in and he has, oh, no, that's from, never mind. That order is from Halloween 2024. I missed the year. He was supposed to be here now to say he finished everything.
No, we gotta set the emails. The emails, we talked about this. He was reset. Miss Jasmine, Miss,
Oh, yeah, look to July 14th, 2026. Okay, so he's not here now.
No. He
All
went
right.
to adult diversion this week though.
For real?
Yeah, it wasn't his fault. That was y'all, it was their fault.
Yep, always the state.
Well, sometimes.
Okay, that's it for diversions. All right, back to the plea and arraignment calendar. Please, position 1, Roderick High. So these first two are old cases. They're listed as transfers from non-complex.
Judge, I'm sorry to interrupt you, but the waiver was filed and the parties were excused.
That's a good interruption. Thank you. Who is this Vernon Smith, the lawyer for Mr. High?
Yes.
All right. So waiver and scheduling order. Okay. Is that true for the first two positions or just number 1?
Number 1, I think the attorney for number 2 is on the call.
Hello, Judge.
Hey, Mr. Majeski, how are you?
Doing great. Good to see you.
Same. It's been a minute. Is your client, I'm going to call his name, Kevin Sinagar?
Yeah, I can
He's
see him.
right here. He's in court. Let me get you on the screen and let's get the podium on the screen. Can't really see you on the camera, but that's all right. So Mr. Sinagar's case was bounced from non-complex to us because of his criminal history. It's a case from 2022. Are you in on this one, Mr. Majeski? As in you remain counsel of record?
Yes, yes.
Okay. It's interesting, there was already a final plea. That's, I guess, when it was identified to be transferred. There was a final plea set in October of this year, not last year. But then it got bounced over here. Do we need to, you already did a waiver of arraignment back in May. Yep. So we're good with the waiver of arraignment. You just need to get a scheduling order, not from NC2, but from Ms. Nelson for us. Did you already get discovery through the DA's office earlier, or will Ms. Smith need to send it?
So, Judge, I was going to make a request. This case bounced all around non-complex for a couple of years for a couple of different reasons. So I think it would be helpful, since it got transferred, if we kind of started over. I got some of the discovery, some of it they're supposed to have been looking for. but then it went through a bunch of different ADAs, and now it's in one place. I think we can finally get everything and resolve it. So if you could help me with that as far as a new scheduling order, I think that'd be very helpful.
Done. We'll do that. So Ms. Smith, good luck. It's an old case. Did you have it while you were in non-complex?
Yeah, I did the transfer.
Oh, look at that. Unlucky you, transferred it to yourself. So we'll do a scheduling order. I didn't realize High and Sinagar are co-defendants. So you'll need to get discovery to Mr. Majeski, as well as to Attorney Smith. It'll have all the deadlines. This is one that the deadlines will be shorter. It's not a complicated sounding case and is old. So I'll be pushing it along. But you'll get that scheduling order, just get discovery out and we'll take it from there.
Okay,
All right. Mr. Majeski, anything else?
No, Judge, can I be excused to go in here to Clayton?
And one moment, I want to just make sure we are squared away with, your client's address. So, Mr. Sinagar, am I pronouncing your name correctly? The address in the system is on Ashton Road in Jonesboro. That's a good place? All right, that's where we'll be sending notices for when you need to come to court. Obviously, your lawyer will know and he'll be reaching out to you as well. But just so you know, if you move, you got to let him know so he can update that address. All right? You don't have an ankle monitor, do you?
Great ones, Judge.
Good. Okay. All right. We're good. You're free to go, Mr. Majeski and Mr. Sinagar. Nice meeting you. We'll see you soon.
Thanks, Judge. Happy Thanksgiving.
You too. All right. Next is McClester. How do you pronounce your first name? Takia. Ms. McClester, how are you? Good. Ms. Nelson, the notes here are that Ms. McClester needed a conflict attorney. Has it been determined that that is Ms. Cabrera?
Yes, Judge.
Okay. Did she do a waiver or are we hoping to see her today?
She did a waiver.
Okay. Ms. McClester, have you spoken with Ms. Cabrera yet?
She just told me that y'all, at the, I came to court, that y'all would call my name to leave like this.
I'm not going to be quite like that, but the answer to my question then is yes, you and Ms. Cabrera have spoken. All right, so you've connected, you've got her number, she's got your number.
Yeah.
That's the important part because that's your point of contact going forward. She'll be letting you know what's going on with the case. She's going to get discovery in your case soon. And then she's going to want to sit down and talk with you about that discovery. So you two can talk about what's next with the case, how we're going to handle it. And I just wanted to make sure, she had a way of reaching you. Are you on Troy Street? What apartment number? Good. Okay. And then your bond, do you have an ankle monitor?
Yeah, from my other case.
Oh, you have a different, another case.
You may want to check with probation on this one, Judge.
What's going on with Ms. McClester? Oh, we let the colonel know? Okay, got it. Okay, your ankle monitor is for your probation? Okay, I didn't know we did ankle monitors on probation. What county is your ankle, are you on probation? Fulton? Okay, what's the case number?
There are two.
Oh,
The first one is 23 SC 191934.
okay. Oh, all right. With a Salahuddin, no less. Okay.
And the second one is 24 SC 002742.
Also Judge Krause. Okay. All right. Ms. McClester, you got a warrant from probation that Judge Krause signed.
Yes.
Okay.
And I would like to my girlfriend out there right now, or she's just up there.
Yeah. You just need to let Colonel know who that person is.
Straight out.
Really? Because of the armed robbery case? Okay, huh. Colonel, I'm sorry, this calendar didn't have a W. Some of our calendars, we get a W and we know. I didn't mean to spring that on you. Okay. And with that, you're leaving, huh? Okay. All right. Patricia Williams. How are you? How do you pronounce your first name? Okay.
I apologize, when I did roll call, I did not hear an answer, so I just need to speak, with short rejection.
All right. So Ms. Wood needs to have a quick conversation with you about your case. Today is just arraignment day, so it's probably gonna be as simple as Ms. Wood saying we're waiving arraignment and entering a plea of not guilty. But she wants to talk to you to sort out a little bit more about what's going on. So we don't have to repeat the conversation since I got you right now. You are on bond. You have to stay away from some address, Norwood Road. That's not a problem? Okay, that's really, looks like the main condition of your probation. You're on pretrial supervision. And lastly, address, I have two. One is on Constitution Road. Okay, and then there's another one, Donnabrook Lane. That's not good either. One of the things Ms. Wood is going to talk to you about is what your address is. She's going to help you fill out a form so we can get a good address in the system. Okay? Do you have questions about anything? Ms. Smith, anything about Ms. Williams's case we need to talk about?
No, Your Honor.
All right, so Ms. Wood, if it is simple as you're going to do a waiver and change the address, Ms. Williams is free to go once you've talked with her. If for some reason, looking at these charges, is working out, we can also sort it out. All right, you bet. So Ms. Williams, don't leave. You're welcome to go outside, but don't leave. Ms. Wood needs to connect with you. In particular, we got to get that right address in there, okay? All right. Sean Harris.
President Judge.
There he is.
Just submitted a change of address with Ms. Nelson. I'm filing the waiver now, so we're entering it not guilty and moving forward to the next court date.
All right, Ms. Smith, anything about Mr. Harris's case we need to talk about?
No, Your Honor.
All right, Mr. Harris, let me cover this same stuff about bond and address with you. Sounds like your address is on the way to being updated, so I won't ask you about that. Your bond. You know someone named Nicole Watson? All right, that's someone you're able to stay away from? Okay. That's it? Okay, we're good. Thanks, Ms. Wood. All right, Mr. Harris, Ms. Wood will let you know when you next need to come to court. Probably what'll be next is she wants to sit down with you to go over the discovery and figure out what's going on. Okay. All right? Tatum Ellison.
He would be mine, Your Honor, but we don't know. I was emailing with Ms. Nelson to try to figure out where he is. He was released to another county, but we're not sure exactly where he was released to.
Do you think he's still in custody or he was then released from that county?
We're not sure. I'm not sure.
Okay. It's not super old. So I think what I'll do if the state asks for it is do a bench warrant, but obviously that'll be set aside if Mr. Ellison was in custody today.
State moves for a bench warrant.
All right, we'll do that. Tara Cameron. All right,
Judge,
Ms.
the parties were excused, the waivers were filed.
Okay, did you send an, I don't mean to make you have to try, did you send an email with any of this info or?
Yes, I did, Judge.
Okay, let me find it. When did you send it?
This morning.
Oh, you know where I've been. Let me find it. Here we go. Ah, look at that. Okay, 7. So Ms. Smith, the attorney is Melanie Elwanger, and she filed a waiver, and we'll get a scheduling order out. Position 8, Carlos Thompson. Ms. Williams says this is her case and she'll be here, but I don't have any info. I don't recognize the defense attorney name and I don't see Carlos Thompson.
Person in our office, Judge,
Oh.
but I have not had any successful contact with Mr. Thompson.
Okay, it's a pretty recent set of circumstances. All right, so we'll do bench warrant and see where that flows. Demoya Ballard.
Judge, she's present, stand up. She currently does not qualify for our services. So I think it might make the most sense to have a reset.
Okay,
To her.
got it. So Ms. Ballard, I guess you financially right now don't qualify for appointed representation, which means you need to consult the open market to see if you can afford an attorney to represent you in this case. What I'm going to do is reset your case and have you come back soon, but after you've had a chance to see if you can arrange to hire an attorney. How much time would you like to try to sort that out? Pardon me? Can you come, I'm gonna have you come on up to the podium, just then we can communicate better. Come on up here, please. All right, I'll try again. I did a bad job of that. I apologize. So, anyone charged with a felony, which you are, you're charged with 2 counts of aggravated assault, has the right to an attorney. If you cannot afford an attorney, then I appoint one. You spoke with people from the public defender's office, and based on your answers about either what you earned through your job or what you have in a checking account, or maybe you own property, whatever the facts are, you have too much money to qualify for a free lawyer. You may not feel like you're a millionaire, but that's not the measure. So you've got enough through hard work or your job or whatnot that you need to hire your own attorney. So my question is, how much time do you want to figure out who that lawyer is going to be? Because I can't move your case along until you either hire a lawyer or you come back and say, I'm not going to do it, so I'll represent myself, which I don't recommend that you do.
What is today?
Like what people normally ask.
I don't know how long. What is today?
So today is the 12th. My thought was we bring you back early in the new year because this is a complicated timing. Normally I say 30 days, but we got Thanksgiving and then the winter holidays are approaching. And so rather than have you come back just before the winter break and say, man, I tried, but it's the people are on leave and whatnot. My thought is to have you come back in January, and you either come back with that lawyer, here it is, my lawyer so-and-so, or you come back and say, I tried, I can't afford it, or this happens sometimes too, between now and then your financial circumstances change, and then you do qualify for an appointed lawyer. You'll have a lawyer in the end unless you simply refuse to open up your wallet. If you have enough resources and say, but I'm not willing to spend it, then I stop the exercise and say, then you're representing yourself. And then you realize that's a terrible idea and you open up your wallet and you hire a lawyer. But we're not in that space yet. Okay?
Mm-hmm.
Did that make more sense?
Yes.
Okay. Let me ask you a couple questions before you go. I've got an address on Bentley Road.
Mhm.
That's you?
Yeah,
Apartment 2910?
yeah.
Okay, good. You are on bond and have been for a little while. And that bond is stay away from Patrick Hoffman and Taylor Fields. Do those names ring a bell?
I don't know them personally. But
Okay, but you know who you need to stay away from.
I don't know what they look like. Yeah, I mean, yeah, I know
Okay.
their names.
Okay, I don't want you to talk about the case. I'm not trying to trick you into saying, yeah, that's the guy I shot. That's not what we're talking about. But I just need to make sure you're complying with your bond, and other than stay out of trouble, which you've been doing, the main condition is stay away from those two people,
Okay.
whoever they are. So as long as you like, oh yeah, those are my coworkers and I'm still going to work, but it sounds like that's not your situation. So I'm going to ask Ms. Nelson, who is a voice that just is going to appear in this room, if she knows of a day when you'd be coming back. We'll mail you a notice as well, but I just as soon you hear it and maybe you can put it in your phone so that you can start thinking, boy, I got to get a lawyer ready for this, okay? Ms. Nelson, do we have a day in January when Ms. Ballard would be coming back?
Yes, Judge. Let me look right quick.
Thank you.
It's going to be January 15th.
All right, so that's just over 2 months, long time to find a lawyer. Can you put that in your phone?
Well, sorry, let me change that. January 5th.
Oop, you just lost 10 days. But it's still the new year.
You said when? I'm sorry.
January 5.
January 5th?
Yeah, it just changed while you were turning your phone on. January 5
At 9 a.m.
at 9 a.m. So this same place, is that early for you?
Hmm?
Is 9 a.m. early for you?
Oh, no,
Okay. You look pained by 9. Do you work?
I do.
Do you work at night?
Well, I work 2 jobs, so.
Pardon me?
I work.
2 jobs?
Yeah.
Oh, this is why you can't afford a lawyer. You work too much. So yeah, January 5th at 9 a.m.
Okay.
And my kid's getting his teeth cleaned that day too. Look at that. All right. Any questions about any of that?
No.
Okay. So if you're not sure about how to find a lawyer, Ms. Wood cannot give you names like, hey, I recommend this person, but she could say, you should call this organization or that organization. Also just go online. But when we see you on the 5th, you need to have that lawyer with you, okay?
9 a.m.
Pardon me?
I understand.
You got it. Okay. You're free to go. Antonia, oop, that's a revocation. Omarion Lee. Hey, Mr. Lee, did we get a C3 attorney assigned for Mr. Lee?
I have Euphemia on the calendar, Judge.
Okay, and it said Sydney Gibson here, but I think that's who was handling it way back when. Oh, yep, look at that. And she just filed a waiver. Have you had any contact, Mr. Lee, with Ms. Cabrera? No? Okay. We're going to get you her contact information before you go, so you can give her a call. She filed a waiver of arraignment on your behalf, which is just entering a plea of not guilty. And she will get discovery from the prosecutor, and then she's going to want to meet with you to talk about your case, okay? Ms. Nelson, can you send me one way or the other, Ms. Cabrera's
Yes.
contact info, please? So there are two revocations, and then Mr. Wallach, we've got your bond hearing with Williams, and we've got Ms. Nix here. So why don't we do that next, the bond hearing, but we just need to I'm gonna get you that phone number before you head out, Mr. Lee. But we can, you just take a seat. I'll hand it to one of the deputies, they'll get it to you. Can we are you good to go, Mr. Wallach, with Mr. Williams? Okay, Ms. Nix, are you ready? Okay, can we bring Mr. Williams out, please? All right, can you please give hey, Mr. Lee, wave your hand to that gentleman, this card, please? Appreciate it. That's the name and phone number for Ms. Cabrera, Mr. Lee. You should give her a call. Even if you get a voicemail, leave your contact information so she can track you down, okay? Yeah, what did I just say? Repeat it back. Yeah, I'll repeat it one more time. That's the name and phone number for your lawyer. Call it. If you get a voicemail, leave your name and your phone number so she can call you back. All right? Okay, good afternoon, Ms. Rivers. You ready to get on the record?
Yes, I am. Good afternoon.
We have Stacy Williams, who is here with his lawyer, Mr. Wallach. Ms. Nix is here for the state. Mr. Williams, you are charged with rape and aggravated sodomy. Your lawyer has filed a motion for bond, so we're going to talk about that. I'll hear from him. I'll also hear from Ms. Nix. There may be someone providing a statement on behalf of the alleged victim. I don't know. Ms. Nix will let us know that. And then I'll let you know today what I'm going to do about bond. That's all we're talking about. That may get into some of the allegations, but no rulings about anything other than yes, bond, and if so, what does that bond look like? Okay? Mr. Wallach, when you're ready.
Judge, would you prefer I go to the podium here?
Just be near a microphone so that Ms. Rivers can hear you.
Okay.
All right? Whatever works best for you.
Well, I'll remain here, and Ms. Rivers, please let me know if you need me to move closer to the microphone or to the podium. Judge, Mr. Williams' wife, Takara Trailer, is present. Ms. Trailer, would you mind just standing up? I just want the court to know that she is present.
All the way from Arizona.
All the way from Arizona. She
All right.
also was present on his last court date, which was September 12th, when he was scheduled for a preliminary hearing. That did not go forward because there was an indictment. But all to say that she has flown in twice now on Mr. Williams' behalf.
Okay.
I did file
You can take a
yesterday
seat.
afternoon a supplemental motion for bond. It referenced exhibits, which were various document copies. Those were sent, those were not included with the filing, but sent directly to the state and to your honor. I assume that you received those, but I did bring those on a hard drive. It makes part of the record in terms of the transcript, or if the court did not receive those and would like to view those.
So I have your supplemental motion. I don't know what the exhibits were, but this is what I have.
Okay.
It doesn't mean they weren't received, but today has been a little bumpy, on my end, so,
Okay. I understand. There, some of them were the various copies of some certificates, some photos of things of that nature, and due to the nature of them and the volume, I chose not to file them. I am going to reference them, so with the court's permission, I will provide the state and you both with a copy of a flash drive that has those. They were sent via a Dropbox link both to Your Honor and to the state as well.
okay. Ms. Nix, did you receive the Dropbox link?
Yes, sir.
So you've had whatever these things are, you've had a chance to eyeball them?
Yes, sir.
Okay.
I approach.
Sure. Thank you.
Thank you. Judge, if for any reason you're not able to access those, or if it becomes easier for me to share my screen on the Zoom, certainly we'll make whatever arrangements we need to make.
Okay.
Mr. Williams is 32 years old. He is born and raised in Arizona. He has no felony convictions. My understanding from reviewing the discovery is he may or may not have a misdemeanor conviction. It appears to be more of the nature of traffic violation, but no felony convictions. He resides in Buckeye, Arizona. He and his wife own the house. They have lived there since 2022. They also own a second property that they purchased in 2025. That is in Avondale, Arizona. That is the reason for the purchase is it was for Miss Traylor's family. Her father is disabled from a stroke and an aneurysm from 2013. Her younger sister is mentally disabled, and her older brother is their caretaker and lives there. Mr. Williams and Miss Traylor have been married for 7 years. They have 8 young kids / young adults who live with them. They have their biological child, children from Mr. Williams' prior relationship, children from Miss Traylor's prior relationship, and then 3 young adults that they foster and or have guardianship over who have developmental disabilities. Included in the discovery is essentially a little family chart showing the children and the relationships in terms of the biological relationships. The 3 young adults who they foster and have guardianship over, there's a 20-year-old male with autism, a 17-year-old male with cerebral palsy, and a 14-year-old with autism. In addition to that, Mr. Williams comes from a large family. He has 6 sisters and 1 brother, and his mother is in Arizona as well. Mr. Williams's grandfather just recently passed. He had a stroke in March, and his health deteriorated significantly since then, and especially once Mr. Williams was in custody. The funeral is scheduled for Monday. It's in Arizona and was scheduled for Monday in hopes that in knowledge of this bond hearing and that maybe Mr. Williams would be able to attend if he was released on bond.
This is his grandfather's funeral.
Yes, correct, Your Honor.
Okay.
Mr. Williams, prior to being incarcerated, Mr. Williams was employed. He worked for All for One HCBS LLC. It is a day training treatment facility with adults with developmental disabilities. He has been there since 2016, so almost 10 years. He is a floor supervisor. As part of that position and because of what All for One does, he is required to have background clearance through the Arizona Department of Public Safety. Included in the exhibits are a copy of the back of his most recent background approval, as well as a letter from the employee. Mr. Williams's job is being held for him, subject to him being released on bond. In terms of the facts of this case, Your Honor, the very short version of it is that Mr. Williams and the complaining witness met online, that they arranged for Mr. Williams to come from Arizona and come to visit her, that they had consensual sex on November 15th and 16th. According to the complaining witness, they had non-consensual sex on the 17th, and according to our version of it, that it was consensual sex on all 3 dates. Upon returning to Arizona, Mr. Williams was subsequently contacted by law enforcement. He was communicative with law enforcement. He retained counsel in Atlanta. Initially.
Not you?
Not me.
Okay.
Not me. Initially, that was a attorney with the last name, and I'm going to spell it because I would not pronounce it right.
I don't mind who it was. I just was, if you had been involved from the get-go, and I was confused because I just saw a motion from you saying, I'm actually kind of new to the case and there's some reciprocal discovery. So
Sure.
Mr. Williams had a different attorney helping him locally while he was still in Arizona, having been apprised, you've got some trouble back in Atlanta.
Correct. So
Okay.
he had an initial attorney. Shortly thereafter, he then retained Jeff Monsiagli here in Atlanta. And both of those attorneys had communication with the lead officer, Detective, I believe it's Felcorn, and that is memorialized in the discovery. Ultimately, there was an arrest warrant that was issued here in Fulton County, which led to a fugitive warrant in Arizona. As I understand it, that's the process. Mr. Williams retained a lawyer locally in Arizona, Adam Feldman. Bond was set in Arizona on that fugitive warrant of $100,000, and Mr. Williams posted that bond through sanctuary bail bonds. There were conditions on that bond, which included him checking in with sanctuary at least twice a week. Paperwork showing that bond and the bond conditions is included as Exhibit 5, and there's an affidavit from attorney Jeff Monsiagli that's included as Exhibit 4. In short, Mr. Williams has been under the advice of counsel and exercised his constitutional and due process rights in terms of this process and has followed their advice. Ultimately, Mr. Williams has been in custody here in Fulton County since August 21st of 2025. This is the first opportunity for bond to be considered. At the initial appearance, the magistrate judge did not have authority to set bond. He was then, as I mentioned, scheduled for September 12th for preliminary hearing / bond consideration.
And got indicted.
Which did not occur.
Yep.
And so we are asking Your Honor to consider bond. While Mr. Williams has been in custody at the Fulton County Jail, he has utilized the in-house education program that's available there through the inmate tablets. He has done self-directed courses. He has completed over 100 courses while he has been there, which I think is illuminative of his character and his conduct. The courses, to be fair, the courses are very short.
They'd have to be, given he's been there 84 days and he's completed 100 courses.
These are not college courses. These are typically an hour, 2-hour courses. But he has completed, as I mentioned, over 100 of them. The list of the certificates of the courses or a copy of the certificates is Exhibit 6, Your Honor. Based on the fact that Mr. Williams was communicative and reachable by law enforcement, that he has remained at the same address, that he has not fled, that he has retained counsel throughout, and multiple counsel through this process, that he was found by Arizona to be a good candidate for bond there, which different finding, different circumstances, but something for the court to consider, that he was compliant and that he has not committed any felonies prior or since then, or obstructed justice or had any improper contact with the complaining witness in this case. I would ask that the court find him to be a good candidate for bond. Mr. Williams will comply with any conditions the court sees fit. I would request that the court grant a bond in the total amount of $50,000. That's a little bit less than I would normally ask, but that is what the family believes that they can come up with immediately, which would enable Mr. Williams to be at the funeral of his grandfather on Monday. Thank you, Your Honor.
What's the bond in Arizona was to keep Mr. Williams out of jail during extradition? Or I'm not understanding why he had to post bond in a state where he hadn't allegedly committed any crimes.
My understanding, and I'm not completely clear on it either, but from talking with Mr. Monsiagli and Mr. Feldman, is the procedure in Arizona is when another state has a warrant, you are entitled to a bond And there is a process where I believe the governor has 90 days to either sign off saying, yeah, we'll, basically comply with this, with what the state wants us to do, or Arizona's not going to comply and, you're on your own. And so that there is a bond hearing that is held and bond is granted. And that was what occurred at that time.
So did Mr. Williams on his own travel to Atlanta and turn himself in at the Fulton County Jail? Or there reached a point where in Arizona, he was taken into custody because what had been an arrest warrant turned into, well, but the indictment was later because he had a preliminary hearing here. So what changed from you have $100,000 bond to now you're in custody?
There is a time period whereby I believe the governor has to sign off. And when that happens, at that point, the bond is no longer valid. You need to turn yourself in. And so at that point, he turned himself in, was in custody in Arizona, was then brought from Arizona to Georgia.
Okay, so he was extradited. There's just this window of time between there's a warrant for you and it becoming enforceable in your home state, where in Arizona, you can be out on bond if a judge deems it's appropriate and you can make that bond.
That's my understanding. I know that there is from a prior client, that there is a similar process in Florida whereby you can be placed on bond even though another state has a warrant for you.
Okay. Why not another $100,000 bond? If Mr. Williams could do it then, why not now?
I mean, the short answer to that is more resources. Where financial resources have been, are less now. They had to make that bond then. They had to hire new expensive counsel now.
Right, they're broke.
So again, Judge, if the court deems that that's appropriate, I certainly understand that. That was what I was thinking in terms of my initial ask.
I'm not criticizing the number. It's just half of what he made just a few months ago. And so I was trying to understand what had changed. And the answer is they have less money now than they had
A
then.
little bit less money, but again, the 50,000 ask is within mind of that's what they felt like. We know we can immediately come up with that to go to a bond contract.
Or Monday.
On such short notice.
Right. Okay.
So just, just for the court's consideration in that, certainly if the court feels that 100,000 would be appropriate, we would certainly be appreciative of that, Your Honor.
Okay. Thank you. Ms. Nix, before I hear from you, we have Ms. Jackson from Pretrial Services on. Ms. Jackson, Mr. Wallach shared that he didn't think Mr. Williams had a felony criminal history, maybe a misdemeanor out there. What can you share?
There are no priors listed in the GCIC, Your Honor.
Okay. Are there, Mr. Williams is an Arizona native. I know sometimes you hit NCIC. Do you have any cycles anywhere?
I do not have any other cycles, just his current arrest. That's it.
Got it. Thank you.
Yes, sir.
Ms. Nix.
Thank you, Judge. To answer your question about the NCIC, I believe Arizona does not report traffic offenses to NCIC like Georgia does. And we did see a FTA on a traffic violation. I don't know whether that was a conviction, but it's a traffic violation. So I'm more concerned about the FTA on that than the conviction.
Good.
Judge, the defendant has no ties to this community, and it sounds like he will leave this jurisdiction. He's going to go back to Arizona. But what most concerns me is that he has a significant risk of intimidating witnesses. Judge, the victim reported to me that either the defendant or his family repeatedly called her family's business, harassing them and threatening them if she did not drop the charges. One of those threats was that they would call defects on her, and they carried through in that threat because in March of this year, she was the subject of a defects complaint. Defects came to her house and immediately realized that it was bogus. I did speak with that defects worker. He wasn't able to tell me much because of the nature of the complaint, but he did tell me that it was very quickly determined that the foundations were unfounded. Ms. Little opposes bond. That's the victim, as does the state. The defendant is at a significant risk of intimidating the victim and witnesses based on his conduct prior to his arrest. We've no reason to believe that if he were to be released on bond, that would change. And so we are opposed to bond. I don't think that his conduct of taking these classes while in custody is relevant to bond, nor is the fact that he came to Atlanta to cheat on his wife.
Do you have, or could you get, based on what you've been told, Ms. Nix, any evidence corroborating Ms. Little and her family's claim that they were harassed by Mr. Williams or his family members? In other words, saved voicemails or texts, or it was always, we answered the phone and someone said, you tell that girl she needs to drop these charges.
My understanding, it was just answered phone calls. I don't know if any voicemails were actually left, but I am working on getting the DFAX records.
Okay. And what about DFAX's visit to Ms. Little makes you think it was in any way instigated by someone other than a neighbor who said, gosh, I heard kids crying a lot in that yard. You need to do a welfare check?
Well, it's the point of time when someone calls and they're threatening to call DFAX on you for no reason. If you have a clean house and you're friendly with everyone, someone is threatening to call DFAX on you if you don't drop the charges against their family member, and then all of a sudden DFAX is knocking at your door. There is a very good reason to believe that the person that called DFAX on you is the person that was threatening to call DFAX on you.
Do you know if DFAX has information that they just either chose not to or couldn't at the time disclose to you about the origin of the complaint?
They do have that information, but they're not allowed to tell me without certain.
What would I need to do to get DFAX to tell you and me and Mr. Wallach the origin of the complaint?
They could tell you with a court order, Your Honor.
Okay. Got it. All right. Thank you for sharing all that. And Ms. Little opposes bond, and that's her communication through you. There's nothing more about victim impact statement?
That's correct. She was considering it, but she's just too fearful of the defendant.
Okay. Thank you. Mr. Wallach, anything you want to add as the movement, having heard what the state had to say?
Yes, Your Honor. In terms of criminal history, Mr. Williams has not, at least officially. What was provided in discovery by the state included some essentially skip trace private background checks, which is what Ms. Nix was referring to. I've attempted to look at those, and I will state my place as an officer of the court. It's very difficult to see whether that is traffic, whether that is considered a misdemeanor in Arizona, whether it's the type of incident where it's in lieu of paying a traffic ticket, in lieu of appearing to contest a traffic ticket, you pay a fine.
Right.
As in regards to the allegations with Mr. Williams or some family member threatening to call DFAX, certainly Mr. Williams and his family will comply with any condition of the court. I will tell the court that there was also a call from that side to this side of Miss Little, the complaining witness's sister, contacting my client and his wife, and making what seemed to be extortion type threats in terms of he has a good job, he's authorized through the Department of Arizona, like that he needs to do this or that. So sure, the state would say otherwise as to that, but it seems to be that at least initially there was a little bit of a two-way street between these two.
Okay. Got it. So, Mr. Williams, I have some medium news and some bad news. The bad news is you will not be back in Arizona, I suspect, by Monday. The medium news is the factor that the state has identified that makes me worry is not risk of flight. I know where you'll be in Arizona, and we can ensure that that's where you stay. Ankle monitors work all over the United States. They don't just work in Georgia. And it sounds like, based on criminal history, there's no risk to worry that you're going to reoffend because there's not at least a recorded history of anything like that. I am concerned about these allegations about influencing or intimidating not just any witness, but the complaining witness. And so I'm going to task Ms. Nix with 2 projects with a short fuse on both, because you're the one sitting in jail while I wait on this and not anyone else. One is to circle back with Ms. Little's family to see if there are any recordings of anything, a text, a voicemail that was left, that's consistent with what they shared with you, their concerns were. And the other would be to get me a proposed court order that has the language that DFAC says they would need to disgorge what they have and wouldn't share. And that'll go to me directly. I may choose not to share it with the lawyers and say, it was good that I saw it. It doesn't move the needle. If it is something that makes me think bond is not appropriate, I will, of course, disclose it to Mr. Wallach and to you, Ms. Nix. I would like to see both those things before I'm comfortable saying yes to bond, and in particular, what that dollar amount would be. For your planning purposes, Mr. Williams, we would start out while you're on bond with an ankle monitor, not to say you have a curfew or anything, but to keep you in Arizona so that it would squawk if you leave the state of Arizona. It sounds like your work doesn't require you to travel out of state. And so the best way to create peace of mind for the complaining witness until there's closure in this case would be for her to know you're not leaving Arizona. That's an easier fix, but that's a cost. Ankle monitors aren't free, so you'd want to be planning for that. And then you obviously be residing at the residence you share with your wife, but you've got that in place, and it sounds like a stable residence, and you've got employment. You need to work. There might be some internet conditions as well, not no internet, but no striking up new relationships online while you are out on bond. But for me, the concern is what you or family members supposedly did, I'm not making any conclusions yet, after these charges came out. So, Ms. Nix, I was thinking a week is enough time to, probably less, but I'll just to keep it simple, say you should, in an email to me, Ms. Nelson, and Mr. Wallach, let us know what you learned from the family about, yes, there are recorded things, and then get those to us if they can get them to you. And then if you can get me that proposed order after you've consulted with DFAC so that the order goes to the right place and says the right thing, I will sign that and I'll make sure it gets to where it needs to go.
Yes, sir.
Okay. Mr. Wallach, anything you want to add before we wrap up?
No, Judge, I was just going to ask in terms of a little clarity on the timing. So Ms. Nix is to report back to you and by email within a week, was that?
Yes, correct. And get that proposed order, and then I'll get that out the door. I don't think Ms. Nix is going to wait till next Wednesday, but this is all unfolding. I just want to give her a minute to get that information. So it would be reporting back to us, you and me and Ms. Nelson. There is nothing recorded or preserved from the family. So it's Ms. Nix relaying as an officer of the court what family told her about unwelcome outreach. The DFACS one ought to be the most concrete, because I'll get that proposed order and DFACS will hand over whatever they hand over. And it may be indeterminate where the complaint came from. And that will be something then that, other than the coincidence of timing, it's not indicative that anything untoward happened from your client's side. But like I said, if it is pretty incriminating, I don't mean of new charges, but in terms of trying to influence a witness, I'll certainly share that with you, so you'd have a chance to say, you're misreading this, Judge, or I want to learn more about it. Decisions on bond are never final. It may be that the outcome isn't what you care for week one, but I saw you're wanting more time to engage in reciprocal discovery, and that may change the state's view about bond after we move through this. So I'm always willing to review a situation as time passes. But for now, status quo until we can get from DFACS what they've got, and if there is anything concrete from the family in connection with the supposed threats. Did that clear it up?
Yes.
Okay. All right. While we're all here, do we need to talk before I finish this? Okay. Can he just come into court? Yeah, thanks. You filed a motion for more time to provide reciprocal discovery. Specifically, you asked until basically into February to provide reciprocal discovery. Can you give me and Ms. Nix a feel for why, that's like 3 months. What are you, 2.5 months? What kind of things would take that long to track down?
Yeah, I mean, Judge, the question really is, or the position really is I don't want to have information that I acquire hearing a defense that I've missed the deadline to provide reciprocal discovery, so therefore I can't use in his defense at trial.
Got it.
I mean, essentially, I mean, he's just been indicted in September.
Mhm.
I just came aboard in September, so I haven't had the opportunity to investigate. I haven't had the opportunity to issue subpoenas. There may be very little or nothing.
Got it. But you may be trying to get phone records and they take 90 days and we're at 60 days and then the state's saying, ooh, this came too late.
Right. And
Okay.
and part of the reason I thought the end of February is also, as you mentioned earlier in court, just we're in the holiday period and everything becomes a little bit more difficult, and we've got Thanksgiving and Christmas break. And so that's why I came up with that date. But that's my concern, Judge.
Okay, I'm looking at the scheduling order. So the state's deadline for discovery is 6 days from now. I'm happy pushing that out. Are you asking to move the motions deadline? You want basically everything to move out?
I don't necessarily need everything to move out. I just wanted to really protect myself and my client in the sense of, you know, if we do come across things that we're not prohibited from using those.
Okay,
As a result of that, any of those other dates need to change. I understand and I'm okay with that.
okay,
The state has provided me with discovery. There's a lot there. I assume it's most of it, as there is in all cases. You know, sometimes there's other things that trickle in.
okay.
But for the most part, I think that they have provided me with certainly the large bulk of it, if not all of it.
Okay. Ms. Nix, I don't mind giving the state a little more time. I just want it to be parallel. But you hadn't asked for more time. Do you feel like the state's universe of discovery you've already got and you've provided it? Or how do you want to work this if I'm going to give the defense a little more time? I just noticed in my scheduling order, it doesn't say when this defense has to provide discovery. There's an ongoing obligation for both sides.
It does say by the same day.
Oh, it says by the same day. Look at that. Oh, so you got 6 days.
Well, and that's
I'd
where
get to
I'm
work.
coming from in filing that.
Okay, got it.
Judge, we've served the vast majority of discovery. I think I am still waiting on medical records. I'm hoping they will be here by the 18th. If
Well-
not, I provide them as soon as I get them.
Okay,
I don't know if the GBI report was included in the original discovery because I think that it was added like just around the same time as I was providing discovery. So that might not be a part of it, but I was going to send kind of everything else at the same time I got the medical records. So there might be 1 or 2 things trickling in, but the
Okay.
vast majority has been provided.
why don't we do this? The motions deadline is January 8th. Other than motions and eliminate. Why don't you all send an email to each other and me and Ms. Nelson on or before January 8th saying, hey, here we are. And Mr. Wallach has looked at things and he's actually good to go. He doesn't need more time to get discovery, or we're at a point where we still need more time. I'm happy to extend that. But it could be that on January 8th, the answer is we don't have any motions. There's nothing to suppress. There wasn't a statement to law enforcement. Can't suppress medical records, that kind of thing. But if on January 8th or just before the email is, we need to talk, hop on Zoom, or it's clear defense need another 30 days or however much time it is, we'll just stretch things out accordingly. But all the dates will move out and we'll go from there. That way you'll have another month and a half of I've been poking around and have a better feel for what's needed. Does that work?
Yep, that'd be fine, Judge.
Okay, Ms. Nix, does that work for you?
Yes, sir.
Okay, and that means between now and January 8th, you can continue to generate discovery, not worrying that you missed the November 18th deadline. No one will be late with discovery before January 8th. Okay?
Yes, sir.
All right. And we will reconnect about bond after we get the information from Ms. Nix and from DFAX. And it may be that we have part 2 of the hearing. It may be based on what I've received. Here's the bond I'm setting. We don't have to have a hearing about that. I can set the bond. Or that I'm not inclined to issue a bond at this point, but we'll revisit it at a later time. But if we get this information and either side says, Judge, we need a chance to argue this more now that we got it, we'll have another hearing. I'm very open to that, and I'm not interested in dragging this out. I just need that additional information. Okay? Mr. Williams, any questions about anything we discussed?
Sir.
Okay. Ms. Nix, anything else on behalf of the state?
Yes, sir.
Mr. Wallach?
No, Your Honor.
All right. Thank you, everyone. We'll talk soon.
I'll come back, Doctor.
Gentlemen on the back row, I'm running late, as you can see. I don't know what your schedule is. I'm good when I finish our calendar, but it's going to be a little while longer. You're welcome to stay, but you may have places you need to be. I'll know that you've stayed because you're right there. If you don't stay, good luck with everything. Continue to pursue the truth. All right. Let's close out this first calendar. What's happening with Ms. Williams?
Oh, I filed a waiver and I put it in the certificate of address.
Great.
And I let her know.
Okay, she's got your info.
Yeah.
Waive and COA and schedule. All right. What about, okay, we've got Johnson and Reed. We'll do those. Those are our revocations. On the inquiry calendar, now that I'm looking at my notes from Ms. Nelson, we dealt with Cameron Wright. Mr. Pearson already pled. So that is done. Mr. Cooper, we dealt with. Shanks, we dealt with. Spears, Dingle. That's going to be a plea? Okay, excellent. And Jones and Kinney are both revocations. And then we've got Mr. Greenway here.
That warrant was dismissed.
Oh, okay. Well, hold that thought. Because we've got Mr. Greenway standing up. You, sir, we're going to hire an attorney.
And I couldn't because remember.
Yeah, I don't see.
I'm going through the federal system or whatsoever, and my money is a whole lot tighter whatsoever.
Okay.
And the prosecutor said that she was gonna file a suit that I get into the deferment program.
The
I heard anything back before I got to court date.
adult diversion program? Okay,
My last court date, this is she said she was gonna try to push for.
okay.
And I can make a plea so that everything will be okay.
Got it. Well, with diversion, you don't even have to plead. You get through that program and it gets dismissed. Okay. Ms. Smith, that wouldn't have been you who said that. It would have been your predecessor. Do you have any information about where Mr. Greenway's case has gone?
I do not. I'll speak with 88 Davis to see what were the prior
Okay.
conversations.
So we have Mr. Greenway here now. Do you mind reaching out to her when we're handling things that aren't yours? If there's anything left that's not yours, except it must everything else. I know Ms. Williams is here, but we actually dealt with her case. So could you shoot her an email? Thanks. Mr. Greenway, take a seat. We're going to see if we can get an update from the lawyer who was the prosecutor on your case last time you were here. All right. Now, federal furlough, I'm not remembering where you worked.
No, I worked at the VA hospital.
Okay. And that is an institution that did or did not receive funding during the shutdown?
No, I was suspended for 2 due to the federal layoff when they did the mass layoff.
Okay.
I have been making work for the last 2 weeks, but I was off of work for a couple of weeks.
Okay, but you're back at work?
Yes.
Okay. All right. I'm glad to hear that. All right, take a seat. Yeah, I bet you are glad. So Mr. Jones's warrant was dismissed. Who dismissed it? I did. Why would I dismiss his warrant?
Well, his office that initiated dismissal, you signed.
Oh, and what was the reason for dismissing it?
They stated that violation of incident prior
Oh, okay, so it wouldn't be a revocable event?
Yeah, it was, the individual was trying to, um,
Okay, is this the only thing keeping him in?
he actually got out.
Oh, he's not up here.
Yeah.
Oh, Deputy Gordon,
He got out last week.
you're not wearing your Spanish clothing. Okay, so there should be no Willie Jones back there. Oh, there's Mr. Jones. What's going on? Like seeing you in street clothes. So your probation warrant was thrown out. Everything else going all right?
Yes, sir.
Have you reported to probation?
Not yet. That's what we reporting on my community service board.
Okay, how much community service do you have?
I think I got like 20-some miles, but probably 60 that you gave.
Okay, that's the 60 that the state asked for? Yeah. Okay, let me see. How long did you have to sit in jail on this warrant?
Actually, 8 days.
Okay. Oh, you're with the CSX case. It still is lingering. Ms. Smith, did you resolve the CSX case yet? You have not. Okay. All right, so you have first offender. You don't want to mess up on probation? No. Okay. Let's see. Community service, stay away from these other 3 guys. Stay away from railroad yards. Okay, and of course, it's going all right? Okay. Ms. Rios, anything else we need to do with Mr. Jones?
No, nice seeing you.
All right. See ya.
All right, appreciate you.
So then we've got 3 revocations, Kinney and Johnson and Reed. We can take them in any order you guys want.
Talked to Mr. Kinney. I've already talked to Mr. Johnson and I'm good on Mr. Dingle. So I don't know what order. 2 things I'm both good on and then I have to talk to 1 person. Those are the 3 things I have left.
Got it. Ma'am in the front row, you are here for whom? Okay. All right. Oh, Ms. Williams, your case.
Yes, sir.
Thompson, position 8. Bench warrant.
Thank you, Judge.
You bet.
And I believe that completes my business.
That's it. That was your one. 1 for 1. Great work. Ms. Wood, do you have something left?
Thank you, Judge. I'm ready on it. I have Ryan Reed. He's position 11.
Got it. Ms. Rios, you want us to do that so you can tie up? I thought you said you had 1 person you needed to talk to.
Yeah. Yes, 1 person. So you're gonna handle that and then I go talk to him?
Yeah.
Okay.
Can we have Reed, please? Ms. Nix, what was on here?
The things that Mr. Wallach said were on there,
What?
photos of the family.
Okay. Oh, and the family tree, right, and all that, got it. Okay.
Who did that?
Hello, Mr. Reed?
His girlfriend.
How you doing, sir?
Okay. All right, Ms. Rivers, let's get on the record, please. This is 24 SC 00174, State versus Ryan Reed. Mr. Reed is on probation and he is here in court with his lawyer, Ms. Wood. We've got, oh, this says Williams next to it. Do we need Ms. Williams back or are you going to handle this revocation?
I'll handle it.
You'll handle it? Okay. I just noticed the charge. Ms. Smith is here for the state. And Mr. Reed, in February of this year, I signed a warrant that alleged you had been arrested, alleged you committed new offenses of possession of methamphetamine, tampering with evidence, obstruction of a law enforcement officer, and public intoxication, all in Clark County, which I think is Athens, back in February of 25. So new charges in another jurisdiction while you're on probation. And so we need to work through the consequences of that. Ms. Wood, is Mr. Reed admitting that he was arrested for these things?
Yes, Judge.
What's the status of the Athens Clark County case?
He's resolved it. Yes.
Took a plea last month. Is he on probation for that case? All right. So what is your, first, how much time remains for Mr. Reed? All right. Ms. Wood, what is your recommendation?
Judge, I believe I'm in agreement with Ms. Simpson's recommendation. We're asking the court to revoke 30 days and terminate this balance so that he'll have the Athens probation there. He does have a case in non-complex. He has a court date coming up in a few weeks, so I've advised him he's being held on a failure to appear for that one. So he's got to resolve that at some point. But he has family in Athens. He's planning to return there, Judge. So I think this recommendation makes sense.
How much probation, either Ms. Wood or Ms. Simpson, did Mr. Reed get for that Athens case? 3 years? Okay, so longer than what's left here. All right. So you pled Mr. Reed here in September of 24. So it was about 5 months before you had your situation in Athens. All right. Ms. Smith, what is the state's recommendation?
Yes, Your Honor, the state will adopt the probation's recommendation of 30 days to revoke and to terminate the balance in this case.
Okay. Mr. Reed, anything you want to add?
Nah, that would be it, sir. I'm just here. I'm listening.
You're just what?
No, sir, I won't have nothing I would want to add on.
Okay, you don't have to add anything at all. Just want to give you a chance. You understand that you've got a second case, you have an open case here in Fulton, and you don't have a bond on that, or you have a hold on that. And so whatever I do here, you're going to remain stuck in Fulton till you resolve that other case.
Is it
It's the shoplifting case. So you already have a court date for that in a few weeks.
all right?
Okay.
All right, that'll work.
Okay, it's not my case. It won't be with me. It's a different judge. We're not resolving that today. We're just resolving, hey, you were on probation. You were supposed to stay out of trouble. And then in February of this year, you got arrested for drugs. And it sounds like you kind of got into it with the officer. That's the allegation. And you pled guilty to it. So you know what that's all about.
So can I ask you one question, sir?
Sure.
So by this being terminated, when I do go in front of the judge on the next charge.
So I think I know what you're about to ask him, and I'll go over that with you in the back.
All right, that'll work.
Ms. Wood will answer the question. All right. Mr. Reed, I find that you violated the terms and conditions of your probation. While you were on probation, you were arrested, pled guilty to these offenses in Clark County. I am going to revoke 50 days of your probation and terminate the balance. So you'll be in custody a while longer for two reasons here in Fulton. One, this revocation, but two, that shoplifting case. You'll be in front of another judge in a couple weeks and do with it as you see fit. Okay? All right. Thank you.
Thank you, Judge. Come back there, Mr. Reed. I'm gonna, no, you go that way, I'll be back there.
Mr. Dingle? Why don't you come on up to the podium? When Ms. Rios comes out, we'll do your plea, okay?
How are you doing today, Your Honor?
I'm doing all right. How are you doing today?
Okay.
Good.
I went to hit her. Why? She's not here.
Ms. Rios, we're going to do Mr. Dingle first, if that's okay with you.
Yes, Your Honor. You got your letters? Got your letters? Do you want to just give them to the judge to see?
Yes, ma'am.
She's gonna get some letters real quick to print to you.
Okay.
You come back. It's okay. Yeah, we're good. Ready to go.
Okay. Well, let's get on the record in just a second. All right. We're going to get on the record in your case now, Mr. Dingle. It's 24 SC 002-347. You're here in court with your lawyer, Ms. Rios. Ms. Smith is the prosecutor. And in a moment, Ms. Smith is going to put you under oath. Once you're under oath, she will be asking you questions about your case and your rights. You'll need to answer all those truthfully and completely. You also should let me or Ms. Rios know if at any point you've got questions about what's going on. Will you do that?
Yes, sir.
Okay. Ms. Smith, when you're ready.
Mr. Dingle, please raise your right hand.
Right hand or left?
Right hand. Do you swear or affirm that the testimony you shall give in the matter currently before the court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
I couldn't hear you.
Yeah, can you state your true and legal name for the court?
Shahid Anthony Spears Dingle.
Okay, could you spell your first name, please?
SHA''HEED.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
And is there any medication that you would normally take that you haven't been given this morning?
No, ma'am.
How old are you and how far have you gone in school?
I'm 30 years old and I have a bachelor's degree.
Are you able to read, write, and understand the English language?
Yes, ma'am, I am.
And do you understand that you are being charged with the following offenses? For the record, Your Honor, count 1, terroristic threats, will be null prost. Count 2, disorderly conduct, and count 3 will be reduced from criminal trespass to also disorderly conduct. Are you aware of those are the charges that you're being charged with today?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
I understand.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
I'm sorry, I couldn't hear the last thing you said.
Okay, I'll restate it. Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
I wish I had longer time, but I have.
So, Mr. Dingle, no one is rushing anything. If you don't feel like you're ready to go forward today with this misdemeanor plea, we should stop, so that your answer ultimately is, I've had the time I need to consult with my lawyer and think about things, and I'm ready to go forward.
Your Honor, if the plea is only given till today, this is the only other option that I have.
Okay, but that's what needs to be on the record then, is that you are interested in the state's offer. The state's offer is for today. You'd like more time, but the state is making its offer open only for today. Is that a fair statement?
Yes, sir. That's
Okay. Based on that, are you comfortable going forward?
I am comfortable, sir.
We will keep going.
Are you satisfied with your attorney's services?
Yes, I am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defense in the indictment for the purposes of this plea?
Yes.
Mr. Dingle, do you remember being arrested for these charges? Do you remember being arrested for these charges?
Do I remember being arrested? Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you aware of any outstanding warrants related to these charges?
I'm not aware of any warrants.
Counsel, are you?
No.
Has your attorney advised you of the minimum and maximum sentence for each charge that you're pleading to here today?
Yes, she has.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 12 months probation? Are you aware that that is the sentence that we're asking the court to sentence you today, 12 months probation?
She's going to read the conditions of it being terminated upon completion.
Why don't you include the conditions, because that seems to be tripping Mr. Dingle up.
Okay.
Thank you.
Are you aware that the sentence that the state will be asking the court to sentence you today is for count 2, disorderly conduct, 12 months probation, for count 3 that has been reduced to disorderly conduct, 12 months probation, for both of those counts to be ran concurrent. Also, for you to complete a family violence intervention program, 40 hours of community service, to seek and maintain gainful employment, and no violent contact with the victim. And if you complete all these conditions, your probation will terminate upon completion. Is that your understanding of the offer that the state is giving to the court today?
Yes, guilty under offer.
She'll get there, but you understand what the state's recommending.
Yes, sir.
Okay.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively, meaning one after another?
Am I aware that you guys can do this? Yes, I am aware.
Okay. Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special condition of probation without being subject to revocation for the balance of the sentence?
Yes, I do.
Do you understand that this is a guilty plea, which means it is permanently recorded on your criminal history?
I do.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance sentencing, including on a federal case?
I do.
Okay. Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial?
Meaning? Could you explain the severity of the end result of what you're explaining?
Yes, for example, your guilty plea may affect your right to vote, the right for you to hold office, the right for you to serve on a jury, the right to obtain a passport, the right to receive, possess, or that's with a felony, or your right to obtain employment.
You're not pleading to a felony, so it doesn't apply to you.
Okay, thank you for clarifying that this doesn't apply to me. I do understand.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, ma'am, I am.
Have you ever pleaded guilty or nolo contendere, or have you ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, felony or misdemeanor under the First Offender Act?
No, ma'am.
And has your lawyer explained the First Offender Act to you?
Yes, ma'am.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes, ma'am.
Do you understand that the federal government considers a first offender plea a conviction for the purpose of deportation and can still affect your ability to remain?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called against you, the right to assistance of counsel either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove that you are guilty for each charge beyond a reasonable doubt, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
I understand.
Counsel, are you satisfied your client understands these rights that they'll be waiving by pleading guilty to these charges?
Yes.
Mr. Dingle, has anyone forced, threatened, or promised you anything for you to enter into this guilty plea?
No.
And is it your decision to waive these rights we just talked about and enter a guilty plea because you are in fact guilty?
Under Alfred.
Under Alfred, because I do not believe that I am guilty.
Are you pleading guilty because you have decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Do I understand that?
Yes.
I understand.
Okay. As to indictment 24SC002347, how do you plead to count 1, disorderly conduct?
So it's actually not count one. Count one has been dismissed. Count 2 is disorderly conduct. Count 3 is being modified to disorderly conduct.
Yes, that's correct.
So how do you plead to count 2, disorderly conduct?
Guilty under Alfred.
And same plea as to count 3?
Under Alfred.
Okay.
Bless you.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes. Ma'am.
I'm sorry.
Yes, ma'am.
Okay. Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
I didn't understand that, but now I do. Thank you.
So it's actually, this just in, the law has changed and you actually have 30 days or the end of this term of court, which is in early January. So you basically have till early January to withdraw your plea.
Okay.
If you want to do that, you're going to need to revise your plea colloquy, but check with your appellate people. The law is now, whichever is longer, 30 days or the end of the term of court. Don't worry yourself with that, other than early January is the end of the term of court. If you're not going to be withdrawing your guilty plea, it doesn't matter. But if that's something you're seriously considering, if you tried to do that in February, the answer would be out of time, cannot do it. Okay?
Yes, sir.
Do you understand that you have 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
That I have 12 months during the probation to challenge.
No, 12 months from the date of your conviction
Okay.
to file a habeas challenge to your conviction, which would be a civil lawsuit you'd have to take care of yourself. You don't get a lawyer for that, where you'd be challenging some defect in these proceedings right here, that I wasn't advised of my rights, my lawyer was no good, although you've just told us your lawyer was great. If you were somehow attacking the validity of your misdemeanor conviction.
I understand that.
Okay, thank you. Your Honor, if this case were to proceed to trial, the state would show that on July 28th, 2022 at 12:01 a.m., Officer D. Jackson was dispatched to a dispute called at the location of 3432 Piedmont Road Northeast, apartment 731. This is in Atlanta, Georgia, and Fulton County. Upon the officer's arrival, they made contact with a male who seemed irate, who was later identified as the defendant, Mr. Dingle. The officer then talked to the victim, Ms. Chriselle Belgemere. I'll spell that. First name is Chrisstelle. Last name is Balegamire. The victim in this case stated to the police officers that the father of her child, Mr. Dingle, was upset with her and attempted to kick in her apartment door. The victim at this time had visible damage to her door and her lock mechanism that was due to Mr. Dingle kicking in the door. The victim and her sister and a friend who was present had witnessed the events, and the victim stated that she was also punched by Mr. Dingle. In this case, she also said she received threatening text messages from Mr. Dingle, and at this time, in addition to the text messages and him coming to the home, she called 911. At this time, the police officers observed Mr. Dingle to be extremely aggressive and irate on the scene. And at this time, they placed him under arrest after they were unable to talk to him and have a conversation with him about what occurred at the home. He was placed under arrest for the crimes that we are here in court about today. And those are the facts of the case. Regarding the negotiated plea between the state and defense, we've agreed for count one, as I stated previously, for that to be no pros. For count two, disorderly conduct, 12 months probation. Count three, criminal trespass that has been reduced to disorderly conduct, for that to also be 12 months probation. For count two and count three to run concurrent. Also, we've agreed for the defendant to complete a family violence intervention program, 40 hours of community service, for the defendant to seek, if not already gainful employment, and for him to have no violent contact with the victim. And this is also with the probation terminating upon completion of the special probation conditions that I just listed. And that's all from the state, Your Honor.
All right, thank you. Ms. Jackson, can you share any criminal history information for Mr. Dingle, please?
There are 3 cycles. The last arrest was August the 2nd, 2023 in Fulton County for simple battery, family violence. There's no disposition for that arrest and there were no convictions listed. Nothing in addition, Your Honor.
Thank you, ma'am. Ms. Rios.
Yes, Your Honor. Mr. Dingle, 30 years old. He graduated from the University of South Carolina. He was doing photography and videography. He also works now at UPS and Alpine
Marketing.
Alpine Marketing. He has 2 children, ages 3 and 1. I'm asking for this to be
4 and 2 now.
Oh, 4 and 2 now. I'm sorry, 4 and 2. And he was in the psychology field and he plans to go back to school for his PhD. We were requesting it to be under first offender. I know typically misdemeanors we don't take it under first offender. But he's 30 years old and doesn't have any convictions. He wants to keep his record clean so he can go to school and continue working. And I did inform Mr. Dingle that once he gets the conditions done, I will file the paperwork to get it to request for the termination. And then after that, for it to be sealed, because he was very concerned about having anything on his record. This was a moment where he was upset. It was the mother of his child. They were having words. He found out some information about her that he was scared for his children, concerned for the safety of his children. And he was upset that there was we didn't receive any proof of like damage from the door, like any prices why there's no restitution. And from my understanding, this was a bad argument. So he just wants to put this behind him and not let this affect his life going forward.
Okay. Mr. Dingle, the two kids are both the kids, how do you pronounce Ms. Ballagamir's last name?
Christelle Bellagamir.
Bellagamir.
His friend.
Are both of your kids with Ms. Bellagamir?
Yes, they're with her at their father's house.
Okay, I didn't ask it well, but the two kids that you've had biologically, Ms. Bellagamir is their mother.
Yes, sir.
And you're obviously their dad, but you said that they are at their father's house, meaning Ms. Bellagamir's father?
Yes,
So their
sir.
grandfather?
Yes, sir.
Is that in the Atlanta area?
Yes, sir.
So you're able to see your kids?
Lawrenceville area, and I am able to see my kids.
Got it. Okay. What happened with the diversion program? Were you in it and you didn't complete it?
The orientation, I was never able to get in due to the situations of me, like I explained last time, getting into the car accident and reaching out to him multiple times, as well as leaving voicemails, text messages, and coming up to the office, just showing face that I am trying my hardest to get into this orientation to complete it. But I went on ahead and did what I could from what was told to me about, the things that I had to do from the diversion, even
Okay.
though I didn't get into the orientation, sir.
Okay. You are entering your plea as an offered plea. That means you are saying, I didn't necessarily do the things that the state said, or this situation was a little different than what the state said, but I, Mr. Dingle, still want to go forward rather than go to trial. I want to go forward with this plea rather than go to trial. Is that a fair statement?
Yes, Your Honor.
Okay. You are also entering your plea under the first offender statute, which means if I sentence you that way, which I'm inclined to do, that this is not a conviction. You'll have a sentence of some months of probation, but assuming you successfully complete that, then this is something that never was a conviction, and you can have excluded from your record, if you will. Do you understand that?
Yes, sir.
The risk of first offender, it's pretty slight as a misdemeanor, is that if while you are under this sentence, you slip up and get arrested for something else, I could resentence you without a trial. And here it would be up to 24 months that you could be in custody if you didn't do well on first offender status. Do you understand that?
Yes, Your Honor.
Knowing those things, do you want to be sentenced as a first offender?
Yes, Your Honor.
Do you have any questions about any of the things we've been talking about that you have not already asked?
No, Your Honor.
I find that your plea is knowing and voluntary, meaning you understand what we're doing and no one's forcing you to enter this plea, and that there's a factual basis for your plea, which is not me saying I don't think it should be an offered plea, but if Ms. Bellagamir came in and her sister was here and they said things consistent with what we heard from Ms. Smith, a jury could find you guilty of disorderly conduct, which is all that you've pled to, which means you acted in a tumultuous manner around other people in a way that got them upset. Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Ms. Smith?
Yes, Judge.
And Mr. Dingle, is it okay if we sign your name indicating your offered first offender plea to the two misdemeanors?
Yes, Your Honor.
I'm going to sentence you on count 2 to 12 months probation. Count 3 will be 12 months probation. They'll run concurrently, same time. You will have three special conditions. Number 1, most important, no violent contact with Ms. Bellagamir. You can be around her, you guys have kids together, but it needs to not be disorderly. Number 2, complete a family violence intervention program. That is a course. It's not one day, it's a series of days. You will need to enroll in that course by the end of the year. You won't finish it by the end of the year, but it will be a requirement that you're enrolled. You provide proof of enrollment to probation by year's end. You will also need to complete 40 hours of community service. Once you document to misdemeanor probation satisfaction that you've completed your community service and the family violence intervention program, your probation can be terminated. It may take you all 12 months. It may take you 6 months. Whenever you're done with those things, you can be done with probation. Make sense?
Yes.
Ms. Smith, anything else from the state? Ms. Rios?
Hey, Ryan.
All right, Mr. Dingle, you will be contacted either directly by misdemeanor probation or Ms. Rios will send you their contact information. You'll want to connect with them because if time passes and they haven't connected with you, all they do is send me a warrant saying, where is this guy? And that's starting first offender off in a bad way. Okay? All right, good luck with everything.
Thank you.
All right, let's do Mr. Johnson next because a very patient young lady has been sitting here. And Ms. Smith, if you check your email, did you get anything back about Mr. Greenway? It's been frustrating to him. It's been frustrating to me. He shows up and we don't ever have an answer about what's going to happen with his case.
Yes, I got an email from 88 Davis that
Yay.
said that she refers him to adult diversion, but he was denied
Okay.
entrance.
That's what we needed to know. So come on up to the podium, Mr. Johnson. Mr. Greenway, you can go. We are going, did you get something in the mail telling you to be here today?
Yes, I did.
Okay, we'll keep sending you things. Diversion's not working out. Not my call, theirs. My guess is it's the nature of the charges. But neither here nor there. You were not accepted in a diversion. So you're going to get a court date to be back here. And you will need to have a lawyer with you. If you don't, we'll have reached the point where you're on your own and you and the prosecutor can talk about the case. And I'm not going to be worried that you don't have a lawyer because we've given you a bunch of months. Okay. I don't encourage you to do that. I encourage you to get a lawyer, but you control your purse, your wallet.
Probation.
I wish you don't think it'd be nothing with you all. I really don't think, like I say, I think you just understanding of what's going on.
Okay, but let's not talk about your case. Not the right time to do that. You see if you get a lawyer. If you don't, when you're here next, then I'm gonna have you and the prosecutor start talking about your case.
No problem. Thanks a lot.
Should I send her over here?
Yes, ma'am. Thank you for being here. We'll see you tomorrow. Productive day tomorrow.
Yeah, I don't know what he'll do though.
I don't know what that means, but I'm intrigued. All right, let's get on the record, please, with our penultimate matter, Mr. Johnson, 23 SC 188706. He's in court here with Ms. Rios. Ms. Smith is here as always for the state. And Mr. Johnson, we are together because you had some trouble while you were on probation. I signed a warrant in September of this year that alleges that you were arrested, in Youngstown. What state? Colorado, Pennsylvania? Ohio, Youngstown, Ohio.
Yes, sir.
For obstructing official business, receiving stolen property. We brought you all the way down here for your Youngstown, Ohio arrest.
Yes, sir.
Okay. Ms. Rios, is Mr. Johnson admitting to this Youngstown, Ohio arrest?
Yes, he's stipulating the arrest, Your Honor.
Okay. What do you know about the status of those charges?
I am not sure what the status of those charges are.
Well, let's ask Mr. Johnson. Have you resolved those charges or they're still hanging out there?
They're still hanging out there. Permission to speak, Your Honor.
You'll get a chance, but let Ms. Rios know what it is you're going to talk about. Of course, being in Ohio was also a violation of probation. Getting arrested is the more serious one, but you need to be a Georgia guy while you're on probation. Ms. Simpson, how much time is left on Mr. Johnson's case?
This case, Judge, he actually had technically 3, but only 2 needs to be revoked.
Okay.
This case, he has a 4-month day remaining.
4 months and 12 days. And what's our other case?
Our case is 14 FB
14.
124 766 is the judgment of the case. He has
5 years, 10 months, 26 days.
Okay,
And then he has another one, with Judge Brewer, that she made consecutive to the first 14 decisions.
you remember Judge LaGrua?
Yes, sir.
Okay, you sound memorable to her. Okay, Ms. Rios, what are you recommending we do across these various cases?
I'm asking for him to be revoked 3 months. He works at Colgate Warehouse, but for the most part,
Here in Georgia, not in Youngstown, Ohio?
yes.
Okay,
But he also watches the children so his fiance can work. And so they have at home, ages of the children. I think it was, how old are the children? 8, 6, and 4. And there's a 17-year-old too. But the young children are the ones that he watches so she can be able to work. I'm asking for, and as far as the Ohio thing, yes, he was in Ohio, shouldn't have been in Ohio. But as far as the arrest, it's the arrest, but he's not stipulating to the actual charges. I've spoken to the fiance about the gun. The gun was not found on him. And I still don't know if that makes a difference, but it was in the facility, but it was not on him.
it was in the car, or it was like, hey, we
was
pulled
in
over
a-
this car and under a tree was a
I don't even think it
gun?
was in a car. It was like wherever they found him. When
Oh, you didn't get pulled, this was not getting pulled over while driving? Okay,
So,
all right.
so I'm asking it for the 3 months to be he's been in for 46 days. So total for him to be revoked 3 months.
Okay. Got it. Ms. Smith?
Yes, Your Honor. It was brought to our attention that there is another arrest, however, an additional arrest to the one that's in the petition, however, it's not in the petition. So I'm going to assume that we're not going to address that one.
We can't, I mean, Ms. Rios could say, let's roll it in, but I didn't know about it. He doesn't know. I don't know what's in the petition. I have the warrant, but unless Mr. Johnson's been put on notice that, hey, we're also fussing at you. Now, that can still come up and get him. What's your understanding about where the arrest was? That also in Ohio?
This one was in, I believe, this one was in East Point, so it was in Georgia. Happened
In Fulton County.
2024.
Okay.
Yeah. But regarding the arrest that the defendant has been on notice about, the state is going to recommend for the 23 SC case for 4 months and 12 days to be revoked, which is the remaining for that probation. And regarding the 14 SC case, the state is going to act for 1 year to be revoked and to terminate the balance of probation.
Okay. Ms. Simpson, the case that really isn't in front of us because it hasn't even started yet, do you know what the sentence is on that one?
It's 2 counts, she revoked, she ran into 5 years probation on count 1, and then 12 months consecutive to 5 years.
Okay, so it's 6 more years of probation on top of, okay,
The first one.
got it. Okay. I'm curious why you were in Ohio. Ms. Rios, can he tell me, or do you not want him to talk about that? I'm not gonna be upset if I can't hear.
It wasn't, I think it's fine. It's just girlfriend vacation.
This young lady or a different girlfriend?
Yes, sir. My fiance behind me.
Okay, and you guys were going to Youngstown for vacation?
Yes, sir. With my daughter.
What's in Youngstown?
My daughter.
Oh, you were going to visit family?
Yes, sir.
A job? You were gonna get a job in Ohio?
Yeah. It's gonna be a
Okay,
roofing.
you can't answer for him anymore. That's okay.
Permission to speak, Your Honor.
Oh, please. What do you want to say?
Oh, I want to see, yeah, going for a country, they had a roof, you know that?
Roofing job.
Oh, it was for a job in Atlanta, but the location was going to be in Atlanta.
Okay, but the interview was in Youngstown.
No, the family member stays in Youngstown, who control the roofing.
Got it, okay. And you were there for other reasons, but while you were there, like, hey, let's see if I can get a job with this roofing company.
Yes, sir.
Okay.
I'm sorry, yeah.
No, it's all good. Okay, I'm just looking through all your stuff. Okay. Anything else, Ms. Rios? So I was trying to figure out what Judge LaGrua was doing with this old case and how did it run, if it was from 2014. You had first offender, your first offender got revoked, and that got you just 7 years, so 7 and 17. I don't understand how the 2014, the 14 SC is still open. Because it was, his sentence was 7 years probation. In theory, non-proton, well, but still 2017. It should have ended in July of 2024.
Are you looking at the adjudication, the
The-
adjudicated center?
The 766, one ending in 766. So he had his first offender revoked. Yeah, and in September 22, 2017.
Sentenced to 5 years probation.
Yeah.
And then we're taking.
Oh, but consecutive to this 12 SC case. I didn't have the 12, so you ended up giving me,
The 12 SC is done.
okay, but so the 7 years didn't start till the 12 SC was done. Okay, all right. Mr. Johnson, you got kids, you got someone who cares about you enough. She's been sitting in court a whole lot. Don't screw it up for them. I am revoking the balance of your probation in your 23 SC case. I am revoking the same amount, 4 months and 12 days from whatever case is still running from Judge LaGrua and terminating that. When you are done with your revocation, you're not on probation. I don't know what's going on in Youngstown. You still have charges up there. And Ms. Smith indicated you might have been arrested more recently in East Point. This does not resolve your East Point charges either. You're going to need to deal with that. Most of all, you want to deal with your family, which means stop getting arrested for whatever's going on. Okay? What were you arrested in East Point for?
I already been, I'm on bond on it, right?
Being out on bond doesn't mean the case is gone. What were you arrested for?
Arrested for simple battery.
On whom?
To be honest, tell you the truth, my other baby moms.
Okay, not the young lady here.
No, sir.
A mother of another child you have.
Yes, sir.
Okay, all right. Again, not my case. That may end up in state court. Just know that what we dealt with today doesn't resolve that East Point case. And it doesn't have anything to do with Youngstown.
Yes.
You shouldn't leave Georgia without, well, you're not gonna be on probation. So never mind what I was gonna say.
Because we won't be able to revoke the consecutive because technically it hasn't started yet.
The 12 SC is still running.
No, not that one. The third, the one I told you that she made consecutive to this first 14 SC thing.
So the 14 SC case is consecutive to a 12 SC case.
This is the one ending 766.
Right, so there's a whole nother case?
She had another 14 SC case that she made consecutive to this.
What's that number?
That is 14 SC 12490.
My gosh, Mr. Johnson.
That's the one that's 6 years consecutive to the 7 years that's consecutive to
The 12 SC, but we're on to the 14 S, we're on to 766 now.
Yes, we're on the.
All right, so that one I can close out. So when Mr. Johnson is done with his revocation, he will still be on probation for another case from 2014. All right, so what I was gonna say is true. Don't go to Ohio without talking to probation. They don't mind letting you travel as long as you let them know in advance. Hey, I'm going for a job interview, or my fiance and I are going for X or Y or Z. And if you've been doing well, they'll say, okay, tell me when you're going to be back, kind of thing. If you haven't been doing well, they're going to say you should stay put because you got arrested in East Point. All right. So that's it. Thanks.
You got 4 months. You got to be in 4 months. You'll get out of 4 months. Mhm. And
Reed was 50 days, we said?
I don't know. That's up to the jail.
Yes,
You don't have to
50 days. This is this. Okay. All right, last case. Is it as complicated? Mr. Kinney.
Hello, Mr. Kinney.
Yeah. I'll get revoked for next.
All right.
Format, because you don't get credit.
Hey, Ms. Jackson, you are good to go. All that we've got left is this revocation. Thank you for your time today. We'll see you tomorrow. It's going to be busy, busy.
Thank you. Have a great one, Judge.
All right, bring snacks. All right, let's get on the record with our final matter, State versus Mr. Kinney. It's 24 SC 003-335. And Mr. Kinney, we are together because I signed a probation warrant in your case in January of this year that alleged that you in Wilcox County, Georgia, had something about pseudoephedrine. You had some cocaine, you had a gun, ag assault against an officer, and obstruction, all in Wilcox County, while you were on probation for a case out of Fulton County. Ms. Simpson, how much time is left in Mr. Kinney's case?
Yes, 3 years and my.
Thank you. Ms. Rios, what's going on in Wilcox County? Do you know?
That is when he was,
I mean, has he been indicted down there or?
It has not.
No, it's just open. Okay. So is Mr. Kinney admitting to the arrest?
yes, Your Honor. But you're stipulating to the fact that you were arrested, you're not.
Yeah, all that means, Mr. Kinney, is that you're saying, I was arrested. I recognize getting arrested is a violation of probation. You're not admitting that you did all these things that are charged. If the state recommends a big old number and I'm inclined to impose that number, you would be able to say, well, wait, I want the state to prove up that I did these things, which they can. I mean, they can try, and they bring a witness in. It's a lower burden of proof than a trial. But on a day other than today, we'd have that hearing where they need to call in witnesses. I'd be most interested in what's this aggravated assault on an officer? That officer might show up and say, hey, he swung at me with a brick, or whatever the story is. And Ms. Rios could defend against that charge, okay?
Yes, sir.
But it may be that people are close with their numbers and we don't go through that. What are you recommending, Ms. Rios? And tell me a little bit about Mr. Kinney.
Yes, Your Honor. He's 24 years old. He has one child that is 2 years old. He's currently living with his mom. I understand this is his first violation. He has been in continuous custody for 10 months. He went from Wilcox to Clayton to Fulton. So because of that, I'm asking for him to, I know since we don't get credit for the time served, to revoke 1 month.
Okay.
Discontinue, not revoke any, continue him on the probation.
Okay, basically revoke 10 months, but it would be credit for the time. That's not how I would pronounce the sentence, but he's been in since this arrest in Wilcox. What was the trip to Clayton for?
He had an open case in Clayton.
Yes, ma'am. It was a violation of probation.
Okay, so the Wilcox arrest was a violation of a Clayton case as well as this case.
Sir.
And you've been working your way through your different issues and now you're here.
Yes, sir.
Okay, so 10 months. Ms. Smith, what is the state's recommendation?
Yes, Your Honor, the state will be recommending for 3 years to be revoked in this case based on the severity of the new charges. The defendant was charged originally with having guns and drugs. Guns and drugs were also involved in this new arrest that occurred. So because of the type of charges, the severity of the facts and circumstances, the state will be asking for 3 years of probation to be revoked, with the remaining to be terminated.
Okay. Have you had an opportunity to review any reports in the case, or do you have what I have, which is this is what the charges are called?
I have the warrant in the case, Your Honor. I was able to look over those facts and
Okay,
things that had.
the warrant isn't more than just this, but like the warrant that an officer swore out.
Yes, the warrant for the new arrest, Your Honor.
Okay, got it. That's helpful. So, Mr. Kinney, I think we are in a space where we ought to have an evidentiary hearing on this. The state will try to prove up what they can prove up, and Ms. Rios will certainly defend you, and she can call witnesses as well or cross-examine the state's witnesses. But I'm going to have Ms. Smith work with my staff to set a date where we can get you back in here for that hearing. That's not 10 months from now. We will have it soon. But these are serious allegations. There may be no substance to them or just a little bit of substance. But if they're 50% true, you had a gun on you on the heels of what this case was about, then there's a big difference between what Ms. Rios is recommending and the state. And I'm not leaning in the direction you'd want me to lean unless I hear more about the case. And hold on. And the way to hear about the case is not for you to say on the record in front of the prosecutor, but it wasn't my gun, or he shot at me first, or I was just a passenger in the car. Those would all be admissions that could be used against you, in particular in Wilcox County. Forget about what's going on here. And Wilcox, their sentences tend to have like an additional 0 on them from what we do. So you want to be real thoughtful about what you say. Now, I will hear from you. Just don't talk about the Wilcox situation, okay?
Yes, sir. So due to the fact that I paid my bond and I'm still fighting those charges, so I still have to sit here until basically get revocated. I basically don't get a chance to get a violation, like a technical for catching the charges and being able to basically do exactly what you just explained and be able to fight for it, and then come back back to court, but from being outside, come back to court.
Right.
Is that possible?
No, because these are not technical violations. These would be, and they're allegations right now, but these would be the most serious kind of allegation. The allegation is Mr. Kinney was on felony probation, and while on felony probation, he committed another felony, and not shoplifting, but drugs and guns, and then that's what you were on probation for. So I think you can understand why I take it seriously, but I have 4 lines of text. And so some officer arrested you for something, and that's really not proof of anything other than you were arrested. I want more information because your lawyer is saying, let him out so he can go up to Wilcox. After 10 months, not just pat him on the back, the prosecutor is saying, we want to revoke 3 more years. I understand both views, and I can't make an informed decision of, you know what, Rios has got it right again, or Smith, I don't know, I want to revoke 3 years and 10 months. So we'll have a hearing, not in 6 months, but soon, where the state needs to prove it up if they can. It's sort of like what you want. You want your trial up in Wilcox. This will be a mini version of that. They can't just bring someone from Fulton. They got to get someone from Wilcox to come in and say, here's why I arrested this guy. And then Ms. Rios will get to poke at them and say, you know what? Actually, Kinney was in the back seat, and everything that was found, it was in the driver's lap of the driver of the car. That's a very different ball of wax than what it looks like on paper. Okay? So that's where we are. We'll work on getting you that date, and we'll bring you back here for that hearing. Thank you.
Thank you.
All right, Ms. Rios, anything else?
No, I will see you tomorrow.
Yes, thank you both. Ms. Smith will see you tomorrow as well.
Yes, see you tomorrow.
Thanks, Ms. Simpson. You were here even longer. You sort of moved into that chair. All right. You guys want to come to the jury room? I am going to grab something. I'm going to eat in front of those guys. My banana from this morning